for your lordship, and your lordship has passed an interim order protecting the petitioner till 11th. Now the matter was returnable 4th, it did not appear. If it can appear, my lord, before 11th, any day.
Check up.
11th এর আগে অ্যাসাইন্ড ম্যাটার, এটা মানডে বা টিউসডে 11 তারিখ অব্দি ইন্টারিম অর্ডার আছে।
Gratuity interest matter. Mention it on Monday. Don't give any slips today.
My lord, my lord, to mention a matter pertaining to upper primary para teachers. This is pertaining to 2016 selection process. There were 10% vacancies were earmarked for them. My lord, the matter was substantially heard by the coordinate bench. My lord,
I'll release it. Give the number.
But,
all the matters, my
all
lord.
the
I have
matters,
heard some of the
there are
petitioners.
bunch of 2025 matters. My lord,
All right.
it was last taken up on 11th. It was supposed to be listed on 6th November. My lord.
All right, then I'll release it if it is substantially heard. Give the numbers. To be mentioned, থাকবে.
My lord, I'm mentioning for transfer on medical grounds.
Not today, madam. Come on Monday.
We need to mention to contempt application, my lord, that is arising.
No, next week. Next week.
My lord, it is of circuit bench Jalpaiguri matters, my lord. Kindly.
Jalpaiguri matter. All right, give.
My lord, I'd like to mention one urgent matter regarding the petitioners were.
Don't read. Say what is it.
My lord, the School Service Commission did not give an opportunity for the petitioners to update their application form as EWS category in the for second SLST 2025.
But then the form was filled up long back. The examination is also over. What you want now?
For filling up the.
How can it be done?
Updating the application.
How can it be done? Where is the scope? Yes.
But the petitioner is not being allowed to resume duty, my lord, since 2021, my lord. This matter is pending. It's a motion matter of 23, my lord.
Yes.
For inclusion and upgradation, my lord.
No, inclusion upgradation not today.
Yesterday, in number 25, my lord,
WPA 4701, which related to the teaching experience standard, the emotional merit standard. And then we get our mistake of the concept where the petitioner, she was a waitlisted candidate, not an impaneled candidate. Because if the order has not been signed by Lord,
Give the number once. I'll check up whether it has been, because none of the orders have been put up in the server today. The files are there.
yes, the order has not been served.
That I know. Give the number. I'll check up once.
My lord,
এটা যদি সই
matter, my lord. Application matter, my lord.
Call the list, please. We decide with. Mr. Shoktipada Jana or anybody from his chamber? কালকে ডিসপ্লে হয়েছে তো দেখলাম। Mr. Jana, are you still there?
Appeal was dismissed, SLT was dismissed, now the petitioner has received all this.
Please come. Learned advocate for the petitioner submits that the order passed by the court has been complied with. The order passed by the Honorable Supreme Court on 15th January 2025 in case number be retained with the records. The contempt application stands disposed of.
I appear on behalf of the review applicant, my lord. My lord, I appear for the response. Pleadings in the matter stood completed. Am I allowed to place my case, my lord?
I file my affidavit.
Yes. Affidavit to the review.
The application for stay.
Stay.
We have filed
in the review.
Yes, my lord.
There is an analogous
GA2.
GA1 was already disposed of. It's for condonation, my lord.
All right.
GA2 is my stay application. My lord, it can be heard altogether, my lord. The review application can be disposed of all along.
Yes, yes.
My lord, this is a matter, my lord, where the petitioner before your lordship is the widow of a deceased employee who was working with Bamal Lorry. But following death of her husband, my lord, what has happened, my lord, she has applied for gratuity and other ancillary benefits. Now, there is a miscalculation so far as the gratuity portion is concerned. Now, in the gratuity portion, we have demanded that there is an entitlement of rupees 8 lakhs odd. Whereas, depending on the HR manual, which has been retrospectively amended as per the version of Bauman Lorry, I have entitled with 2 lakhs. So your lordship was pleased to dismiss. My lord, following dismissal, what has come up, if your lordship please to come to the, there is a notification at page 158 of the stay petition. This document was not available at the time of filing of the writ petition. Oh, my lord, this document has been, my lord, payment of, if your lordship has got,
Yes, page 1.
payment of family pension, death gratuity, and other dues to the family on the death of the government service during service regarding the undersigned is directed to say that the COVID-19 pandemic. So it was specifically, my lord, on the ground, the person, the deceased employee who has passed away due to COVID, my lord. This has been specifically made applicable on that count itself. But this document was not made available before the review applicant or the petitioner at the time when the writ petition was heard. So this is the only point on which I am assailing this review application, my lord. Now, my lord, so far as my learned friend is concerned, there is a point of maintainability which has been taken in this regard.
Yes, yes.
Well, the point of maintainability, there are 3 different scores which I have understood upon going through their opposition. My lord, the first one is the review application has been filed by a different set of advocate who was not engaged at the time of writ petition. My lord, that is not permissible. And in this regard, my lord, there is a judgment of 1975 Supreme Court, if I may rely on. My lord, this also says the same thing, that it is not permissible, and this has been followed after also till this date.
It's not permissible.
My lord, filing by a different set of advocates. Now, reasoning is important, my lord, why it is not permissible. Why the change of counsel at the stage of review is not permissible? Because it talks about the scope where the matter cannot be re-argued on the same score. My lord, my contention is that Order 47 permits that if a document which was inadvertently not been brought into the record, which ought to have given a different perspective or outcome of the matter at the time of hearing, then a review is maintainable. I am not here, or the newly engaged counsel is not here, my lord, to re-argue the matter on the same thing. So this has to be the point, whether a counsel can be engaged at the stage of review. It has to be read with the parameter of Order 47, Rule 1. This is my first answer to the point of maintainability. Second, my lord, they have stated, they are denying that there is the person who has passed away, the employee, the husband of the petitioner, has not died due to COVID, my lord. In that regard, my lord, if your lordship be pleased to take my affidavit in reply for one. The very last annexure, page 12.
This is the memorandum of review. Affidavit of accomplishment. Yes, page 12.
Page 12, the last annexure, my lord.
Yes.
My lord, this is a certificate issued on my saying, my lord. It was subsequently, and if your lordship be pleased to peruse the date at the top right hand, 12/8/2025. This was by the Union Territory of Dadar and